Congo against the Secretary of State for the Home Department.
My Lord,
Yes.
can I just mention something about the timetable? Originally it was intended that Mr. Belloff would commence his submissions at midday today. We're confident that Mr. Belloff will be able to commence his submissions certainly before lunchtime.
Yes.
And Mr. Belloff has very kindly indicated that he's as relaxed as he normally is about that state of affairs. We're very, very grateful to him.
I emphasise the adverb normally.
We're very grateful to him for that indication. My Lords, I have prepared an outline submissions on the Hardwell Singh issue, which you ought to have. There also ought to be an updated index, as asked for by Lord Hope. We very much take
Yes, we have.
very much take on board my Lord's comments to me yesterday morning. My Lords, the issues arising in WL's case alone concern the proper scope of the Hardwell Singh limitations on the exercise of the detention power, which, as we have seen, is very broad and temporally unlimited. And this is the first time this question has squarely come before the Supreme Court or the House of Lords since the case was decided over 2 decades ago, although the issues have been considered in a more tangential way in the Tanti Lam case, also in Kadian, and also in Belmarsh. My Lords, turning to my note, you will see the basic facts of the case, which we say are troubling as regards the length of time this man has spent in administrative detention. It has been 53 months since June of 2006. He suffers from very serious mental health problems. He is a paranoid schizophrenic. A care plan is in place for him. The reference to that is 3A, Appendix 3A, 2329. He has a British citizen child. We accept that for a 5-year period, he was what could be described as a chaotic recidivist offender, guilty of some offences of violence. Mental ill health was a factor in his offending. That the references there are to a probation officer's report from 2005, and also to a reference to the determination of the appeal tribunal. He has been found to be a real absconding risk, though it is agreed that he has never absconded. He's also found to be a reoffending risk. He has been detained for a considerable period of his 53 months in detention, pending appeal and judicial challenge. And the possibility of voluntary return has been held against him. His administrative detention has lasted almost twice as long as his criminal sentence, and that is something, point of comparison is of interest, and we cite the EU Agency for Fundamental Rights, which is an EU advisory body set up by a council regulation in 2007. We cite their report, 32324, page 48, to the effect that the length of detention pending removal should be seen in comparison with sanctions provided for criminal offences. And the UN Working Group, in a report which they prepared on the case of A. Somalia, the Abdi case, the first Abdi case which Mr. Westgate referred to yesterday, have said that it is difficult to think of circumstances under which this duration, that was 54 months in that case, would not be excessive. And that case, as I think I mentioned 2 days ago, was a case concerning a horrific offence of the rape of a child for which the appellant received an 8-year, 2-month sentence. the working group said in his case that 54 months, it would be difficult to think that that wouldn't be excessive. Mr. Justice Collins, at paragraphs 39 and 65, discounted the period that WL had spent on appeal. At the time before him, that was from June to December 2006. He calculated detention excluding that. He held the possibility of voluntary return against the appellant, found that he was a real risk of absconding, considered that his mental illness could be and was being managed in detention, and then very oddly, he prospectively ruled that WL's detention was lawful. And you see that most clearly from paragraph 3 of the judge's order at page 115 and at paragraph 100 of the transcript during the post-judgment exchange.
This is in Court Volume 1, is it?
Two, I think.
My Lord, yes.
Two, I think.
Is it, or is it 2?
Part 2. Appendix 1A.
Appendix 1A, which is core volume Roman 2. What had happened was that being late disclosure of the secret policy in the skeleton argument prepared the day before the hearing, before Mr. Justice Collins, what Mr. Justice Collins did is he held the balance of the issues as he put them over to another hearing. And that is what became WL2, Lumba, Abdian Lumba, before Mr. Justice Davis. He dealt with the issue of current legality of detention in his judgment of the 4th of July, but very oddly ordered, if I may say so, or unusually ordered, that at that future hearing, the claimant shall not be entitled to seek a mandatory order directing his release.
Mr. Hussain, can I just be clear how all these submissions, the Hardial Singh part of your argument, fits in with your general case? Your primary position is that detention was unlawful ab initio.
Oh, yes. Yes.
So if you're right about that, then that carries you home, or does it?
It would carry me home on the question of liability and false imprisonment.
Yeah.
It may not carry me home on the question of damages assessment.
But I'm just wondering how Hardial Singh fits in, if you're right on your primary submission.
It goes to the question of release and current legality, because if my lords, my lady find that the detention was unlawful ab initio, it would be open to the Secretary of State to reach a lawful decision today or cure any defects by reaching a decision. Indeed, that is we say that is the proper approach. If an individual moves a court and complains of errors, it is still in detention, the proper approach is for the court to require the Secretary of State to properly consider the issue, rather than consider it for itself. So the reason the Hardial Singh issue is primarily relevant, assuming we're successful on the common case, on that assumption, is that it speaks to release. It would also speak to the question of damages, as I mentioned earlier. If my lords are against my submission on principle on the causation question, then there is another issue about which we didn't take time to make oral submissions on, but it's in our case. At part 2, there's an issue about causation. I'm sorry, if the causation test is correct, there's an issue whether it was open to the courts below to conclude that he would have been detained for this period of time in any event.
Yes, I see.
It's a curious feature of this case that both sides agree that nobody has looked at the compatibility of this man's detention with the Hardy-Singh principles since July 2008. Because Mr. Justice Davis looked at the issue as it was on the 4th of July. He rejected a submission made to him that Mr. Justice Collins' judgment and order wasn't binding on him because of the Greater Manchester Crown Court TAL principle. Obviously, it carried great weight, but the submission was made to him that in matters of liberty, he should not be constrained by it. But he rejected that submission. And so he, in December 2008, had a retrospective focus. And then the Court of Appeal, at the end of 2009, also declined to look at the matter as to look at the issue as matter stood before it, and simply just adopted the what I might say is the orthodox perspective which an appellate court would adopt, a perspective which we say isn't appropriate in these cases, still less in a case where there had been that retrospective element already at first instance.
There are two separate issues, aren't there? One is the damages issue. At what point in time did WL's detention become unlawful on Hardy-Singh principles, if such a stage was reached? That could go to damages. And are you suggesting that that's something that should be determined by this court, or that if it, in principle, is the right test to apply, it should be sent back to the judge at first
I think
instance?
we would probably, we would invite you, and it's something I address right at the end of this note, if you detect errors of principle in the courts below on matters of historic detention, we would say it's appropriate to send the matter back, because one would be looking at the issue in a lot of detail, which wouldn't be appropriate in proceedings at this level. One would spend a fair amount of time doing that.
Sorry, I was just going to get the second, is kind of slightly overlapping with your principle, which is if you have an applicant who is still detained at the time that the matter comes before the Court of Appeal or this court, is the court in question required to consider whether he should be released, as it were, on the spot?
We certainly say that the Court of Appeal is required. So not a question of jurisdiction, it's required to consider the matter as at the date of hearing. This court is, of course, the issue is very different, and we exceptionally invite this court to consider the question of release if it thinks that it's just gone on too long now, and you plainly have jurisdiction to do that. You have jurisdiction to decide anything which you think promotes justice under Section 40 subsection 5 of the 2005 Act, and you inherit the jurisdiction of all the courts below under Rule 29 of your rules. So you've plainly got jurisdiction to do that, but no, we don't go so far as to say you're obliged to do it, because you're plainly not a second Court of Appeal. But we say where liberty is concerned, the position is different. A fortiori, where the courts below have, we say, I'm afraid, have abdicated their responsibility. Certainly the Court of Appeal, we say, abdicated its responsibility to look at the matter at the date of hearing before it, and did so on grounds which we respectfully submit are completely untenable.
And if we may, why aren't we required to do so under Strasbourg jurisprudence as a public authority?
Because I think the issue arose in the Ottman case as to whether or not an appellate court was always required to reach a first instance decision, as it were, a first instance decision. And I think what my Lord held was that and I'm paraphrasing badly, was that the distribution of competence in the national legal system was a matter for the national legal system. We would say that there is a precedent for the highest court, the Privy Council, entertaining an application for release, the Tanti Lam case, in fact. But in that case, the Privy Council held that it was an unusual course. And we would accept that, we would respect your status as a court which decides questions of general public importance rather than being a second court of appeal.
Well, it's not really a second court of appeal, is it? If circumstances have changed between the hearing in the Court of Appeal and the hearing before this court.
My Lord, I see the force of the point. I would say if we get through the, I suppose if one has got through the gateway...
It would be highly unsatisfactory if this court in every case had to go back, can have a ab initio factual consideration, but...
Yes, but it's why I say you're not obliged to do it. But we say it's a sufficiently clear case and there's sufficiently good reason for you to entertain that question in this case, particularly given the way the courts below approach the issues. Can I just finish my answer? I'm sorry.
Can I just ask, is the UK doing forcible returns to Congo at the moment?
I don't think there's an impediment to...
No impediment?
No.
Any legal impediment? Why?
The legal impediment is that the appellant has appeal proceedings in progress against a refusal to revoke the deportation order that was signed against him. The refusal to revoke the order was the decision to refuse to revoke the order was made in July of last year. And
I see. The appeal process is still ongoing.
It's still ongoing.
I see.
Yes. Yeah, and we'll come on to that. Obviously, it's a big point. What happens to time spent in detention pending appeal? Just to complete my answer to my Lord Sir John Dyson's question, if we're wrong on causation, then you apply a causation test, query what model you use. We say the model you use is, was detention inevitable on the basis of whatever policy would have been applied, and you assume legality, although it's an assumption we respectfully submit is maybe difficult to sustain, which goes to the primary point, but you judge whether or not the individual would have been detained in any event by reference to the policy, not the Hardy-Singh principles, but the Hardy-Singh principles are a fortiori the policy. The policy gives greater protection, that's accepted by the Secretary of State. So that's the final way in which there is a link between the two issues, if that's not too unclear. Anyway, my Lords, Mr. Justice Davis addressed the issue at paragraphs 202 and 203 of his decision, and he essentially endorsed what Mr. Justice Collins had found. The critical paragraph is 202.
Page?
112, my Lord. You see there that he just doesn't look at, he declines the submission that he should look at the position after July 2008. Implicitly declines that.
I haven't quite followed this through, but does he give reasons for paragraph 3 of his order?
Mr. Justice Collins?
Yes.
Well,
you say, and I think I follow this, it's a rather odd order to make, but so I would expect some kind of explanation.
There's a post-judgment exchange at page 140. You'll see at paragraph 97, submission is made. My concern is to clarify, following the further hearing, it's still open to me to seek a mandatory order. It's Mr. Goodman for WL.
Yes.
I think not. In that case, I'd seek permission to appeal. And he does say at paragraph 100, subject to change of circumstances. And what was put to Mr. Justice Davis was that the fluxion of time by itself is a change of circumstance. But implicitly that was rejected, that submission was rejected by the judge. Now, my lords, my lady, the Court of Appeal deal with the issue at paragraphs 98 to 108 of their judgment. And they quote extensively from the judgment of Mr. Justice Davis, and that their own reasoning begins at 101. I should just mention that Mr. Beloff's concession, for which we're grateful, means that the court's finding, which we say wasn't clear as to the question of reliance, as to whether or not the policy was applied at all, irrespective of whether it was causative of detention. But if the question of whether it was relied or not, you can ignore our submissions on that. As Mr. Beloff said, that issue falls away. But on this issue, the Hardiel Singh issue, they begin their consideration at 101, the second sentence. The real attack is against the judgment of Mr. Justice Collins. And they essentially endorse the approach which he took. And at 102, they say the fact that an FNP is refusing to return voluntarily or cooperate is relevant to the assessment of legality. And that is, we say it's not clear, but insofar as it's an endorsement of the submission made that detention pending appeal is irrelevant to the assessment of Hardiel Singh legality, we say that the Court of Appeal erred, and that submission is, we say, fundamentally wrong. And then they say, that paragraph, they cite the A case, and then they say, so is the fact that the period of detention has been increased, deportation postponed by pursuit of appeals and judicial review proceedings, seeking to challenge the order, particularly if the applications are obviously meritorious, query the role that merit plays, in their view, on the issue. In our judgment, as a matter of principle, an FMP cannot complain of the prolongation of his detention if it's caused by his own conduct. And they quote a number of cases. At 106, they say there was no material error in Mr. Justice Collins' approach. At 107, they say that they cannot rely on the directive, EU directive, the returns directive, or the ECJ judgment in Kadzoev, because the UK had opted out from that directive. We say that the directive is relevant to Article 5, how Article 5 would operate. I'll develop submissions on that in due course. And then they decline to look at the period of time at the current position in paragraph 108.
It's your submission is that one should always consider the period of time, regardless of what the cause of it is, even if an applicant is behaving in a way that's vexatious, if he's refusing reasonable cooperation, destroying his documents and that kind of thing.
Well, you would reduce the importance you attach to the period of time that such a person had spent in detention. You wouldn't reduce it to nil, because there comes a time where enough is enough. We respectfully submit, and we are supported in that, we say, by dictate of the courts here, and also the approach in Strasbourg and indeed the ECJ. There's always a time where enough is enough, but we certainly don't say that you disregard that. Of course you pay regard to the merits of the appeal. Of course you do.
Did I gather you to say, going back to 102, paragraph 102, just above letter D, that for it to be held against him that he was pursuing appeals would be wrong? Are you challenging that reasoning? There's a sentence there about the pursuit of appeals and judicial review
Yes.
as increasing the period of detention, and therefore, in effect, it's his own fault.
Yes, we say that's profoundly wrong.
That's what,
Profoundly wrong. Profoundly wrong. Which I can give you reasons right now, but
I mean, it's the particularly of which is a bit amusing.
yes, it is amusing.
Does it?
Either it does or it doesn't.
Either it does or it doesn't.
Yes.
Yes.
In a sense, the reference to merit is the antithesis of the preceding clause in the sentence. My lords,
Because all they could mean is that there were underlying reasons why continued detention was justified.
Yes.
But the period, of course, is being extended because he's appealing and therefore is delaying the
Yes.
possibility of his return. It could be all, that could be all they're really getting at here.
we respectfully submit it's not clear. In our case, we've said insofar as the Court of Appeal endorsed the exclusionary rule for which the Secretary of State was contending, then that it hurt.
but I mean, Lord Justice Toulson's pretty clear, isn't he, at 105? Anything wrong with that?
We do say that approach is wrong. Well, also, if I can probably it'd be more efficient if I took you through the areas I wanted to take you through. We say, essentially, with respect to my Lord, that my Lord Sir John Dyson has got this right. And everybody else has not quite got it right or got it wrong. With great respect, that's our position. My Lords, can I make brief submissions about the context, if you go back to my note?
Well, could you just show us what Sir John Dyson said, which is relevant to this, so if this is what you're about to talk about?
Yes, it's the...
What is right about his as opposed to somebody else's?
Yes. What my Lord Sir John Dyson says in the I case...
Could you, where do we
That's
find
the
that?
top of page 2210, isn't it? Just at the very end of paragraph 104, I think is the bit you're referring to. Last sentence.
Yes, no, but if you read... If you go to the judgment itself, so I take you to I'm happy to take you to I,
Yes,
which is at 12... Sorry? 12.123.
Sorry, 12 which?
Volume 12, tab 123.
123.
This was the case of the Afghan asylum seeker who had convictions for indecent assault and so forth. Voluntary returns had just resumed at the date of the hearing, but he'd been in custody for nearly 16 months without indication of when enforced removals might become possible. And there was a difference of emphasis in the judgments of my Lord Brown, my Lord Sir John Dyson. My Lord Brown looked at the Tanti land case at paragraph 13, page 201. Where the Hong Kong Ordinance made specific provision for whether or not the person had declined to make declined arrangements made or proposed for his removal. That the subsection expressly based on the requirements detention must be reasonable, but imposes specific requirements that in judging such reasonableness, those two factors are to be taken into account. And that generates the reference to self-induced, the idea of self-induced detention, at paragraph 14. And my Lord notes at paragraph 17 that the position before the court was that voluntary return has been resumed could be achieved within 2 or 3 weeks. At 20, my lord observed that the reference to removal being possible within a reasonable period of time had to have regard to the period of time already spent in detention, which is obviously material here. You then looked, my lord, at the question of risk of absconding and offending. You preferred the submissions of the Secretary of State on the offending issue and reoffending issue as well, at paragraph 29. And over the page at 205, you held that the likelihood otherwise of absconding reoffending, obviously relevant circumstance, reference to murder and mayhem. Voluntary repatriation, you considered it.
Just leave it before we leave 29. Do you accept that the likelihood or otherwise of reoffending, I think you do accept the likelihood of absconding is a relevant factor?
It's obviously relevant.
Obviously relevant,
yes.
But what about the likelihood or otherwise of reoffending?
Our submission on that is that cannot be the reason why you detain.
So you don't accept that part of paragraph
No,
29?
it has to be, it's contingent on there being a risk of absconding. And the reason for that is that the purpose of the detention is deportation. It is the purpose of the deportation may be to prevent reoffending. It may be something else. The deportation power at the moment is predicated on a finding that a person's presence is not conducive to the public good. That may or may not involve offending. Family members who may be entirely innocent and of good character may also be deported under 3.5b.
Not if they're British citizens.
Of course not, my lady. Of course not, no.
No, well, that seems to have been overlooked in this case.
Yes, it certainly was. And I have my lady's points in mind. Yes, the idea of constructive deportation of own nationals.
You said a moment ago that the object has got to be deportation.
Yes.
And I know Strasbourg's dealt with the question of whether it's got to be necessary for deportation. It seems to me quite probable that the original thinking under the deportation exception was simply this. If somebody comes into your country who's got no reason to be there and you don't want him there and you're going to get rid of him, you don't have to allow him to wander around wherever he wants to go in the interim.
Yes.
As simple as that. Provided that you don't want him, he's not allowed in, and you're going to...
No, it's extradition or deportation. That's what it says in 5.1f. It doesn't say voluntary departure or something else, and you construe 5.1f narrowly.
Yes.
And there are at least two grounds.
Our domestic approach to this, and maybe Strasbourg's, has considerably narrowed the circumstances in which it's lawful to exercise this power, but it's just suggesting to you that the original thinking may have been a very simple one. Well, you don't have to allow people to wander around your country if they've got no right to be there and you don't want them to be there and you intend to get rid of them.
Yes, but we would respectfully submit that was the legal Middle Ages, 1950.
Yes, okay, fair enough.
Yes, but that's with respect irrelevant to the position, completely irrelevant.
It begs the question of how long you can keep them in detention. I mean, I'm sure that what Lord Phillips has said is right as the starting point.
Yes.
But the question is, how long can you keep them in detention and say we're going to keep them in detention for the purpose of deportation? And that's where Hardy Al Singh comes in.
Yes, but it must be for the purpose of deportation. It's not for the purpose of trying to coerce their voluntary departure, for example, voluntary repatriation. That's the first point we make. And the second point we make is that preventative detention is anathema to the Convention. And if the only reason you're keeping somebody in or you're prolonging the period of reasonableness is because you think they're going to offend, well, that's not acceptable. The key consideration is absconding risk, because that frustrates the deportation machinery. It's deportation which is the purpose, not anything else, or extradition under 5.1f.
Well, I mean, this is why I put to you the original thinking behind it, that you don't have to have somebody who's undesirable, that you don't want in your country wandering around. Now, a fortiori, if he's not merely somebody you don't want because he's an alien, but he's a criminal alien who's committing horrific offences, why is that not a relevant factor?
Those were my Lord's. That was my Lord's starting point, if I may say with very great respect. That was my Lord's starting point in the Farrakhan case. It was my Lord's starting point in the Ullah case. Farrakhan predated Ullah in the Lordship's House, where the Court of Appeal judgment was overturned. And it was also before Belmarsh. So there have been considerable movement and considerable clarity given to the underlying starting point issue. Immigrants have the right to liberty. That's very clear. And my Lord doubted that in the Nadaraja case, I recall. And in the Ullah case, my Lord held in the Court of Appeal, premised on that thinking that the only article of the Convention that applied was Article 3, and that was overturned by the House of Lords. So whatever the original thinking 60 years ago,
yes,
it's miles away from where we are now.
I entirely accept that
Yes.
we've progressed since then, but
Yes.
if one's trying to establish what is and what is not relevant.
Well, you could do that very easily by looking at two Grand Chamber decisions which say that you construe the exceptions to the right of liberty, and they're dealing with 51F, they're dealing with terrorists, they're dealing with Belmarsh, and they say you construe the exceptions to the right to liberty narrowly. What does that mean? It means that the detention must be for the purposes of extradition or deportation. That's the purpose. Now, that may also have a secondary purpose of preventing crime, but it's a secondary purpose. And we say that cannot be the purpose of the detention. And the problem has been, we respectfully submit in the case for the Court of Appeal level, the movement from the purpose of the deportation to the purpose of the detention. And that is very suspect, we say, firstly on first principles, and secondly, because there's no necessary connection between deportation and prevention of crime. Because until 1999, you would be deporting overstayers. And now, okay, they committed a crime, they committed an immigration offence, but that's not what's being said in these cases. So there's no necessary connection between deportation and prevention of crime. It may well arise in cases, it arises in these cases, no doubt. But that is, it's still impermissible to apply that and say, well, we can justify your continued detention on that basis, if it's the only reason.
If it's the only reason.
Yes, we accept it's relevant.
Yes.
We've always accepted it's relevant. But you've got to have an absconding risk. It's the absconding risk which frustrates the deportation machinery, and that's obviously relevant, as my Lord Brown, Lord Sir John Dyson held.
So far as criminal conduct is concerned, the hypothesis must be that that has been dealt with by the criminal process. A sentence has been passed,
Exactly,
the sentence has been served.
Oh, exactly.
Otherwise, of course, if the sentence is still running, this issue wouldn't arise at all. But it arises because they've been released from their period of imprisonment.
The criminal courts, the judicial arm of the state, has decided what punishment is necessary for the purposes of retribution, deterrence, and prevention. It's decided it.
And if there's a fresh offence committed in prison, for example, or somewhere else, well, that will be dealt with under the criminal process.
Yes, absolutely.
I find this very strange. The Secretary of State decides he wants to get rid of somebody.
Yes.
He wants to get rid of him because he's committed some horrific crimes and he's a danger to society.
Yes.
And you say, you can't have regard to that as a relevant consideration in saying he must remain detained, unless also there's a risk that he's going to abscond.
Yes, because preventative detention is anathema to the Convention, and it's anathema to our legal system. Completely anathema to it. And it doesn't change just because you're an alien.
Doesn't change that that's the very reason you don't want him in your country.
You want to deport him, yeah, but that's
You want to
exactly...
deport him because he's a danger to society.
No, but my Lord's question,
Yes.
it hits exactly the right point, because That's the reason you want to remove him.
Yes.
It can't be the reason you detain him. The detention has got to be that you want to deport him. The secondary reason, the reason for the deportation, cannot be, we say, taken across to the reason for the detention. It's relevant, but only when the machinery of deportation is going to be frustrated by absconding.
Well, then how does it augment the absconding factor?
Well, because you would say you have one person who is going to abscond, but there's no risk to society, and they've been in detention for a protracted period of time. There's no real prospect of them being removed, and you think enough is enough. If you have the same case which comes before you, but there is also a danger to society through reoffending, then you would be entitled to say, well, the reasonable period hasn't yet passed. It's relevant to the assessment of what's reasonable. But merely to keep somebody detained in circumstances where they're not going to abscond or frustrate and so frustrate the deportation process, we say that cannot be a basis for keeping them in
Maybe
detention.
there's a temporary block on being able to deport. It's not a question. The risk is not that they're going to abscond,
Yes.
but that there it is. There's a delay in being able actually to implement return. And in those circumstances, no risk of absconsion. But if you let him out, you know he's going to start committing, as I put it, murder or mayhem. You say that's not relevant because he's not going to abscond.
Well, yes, but my lord, in that situation, the reason you'd be detaining him is for preventative purposes. It's purely for prevention of crime.
Exactly the same reason that you're deporting him.
In that case.
Sorry, is there an authority which tells us that this is actually an impossible consideration?
I don't think there's a direct authority.
Well, is there authority at all which tells us that's apart from things which say you narrowly construe and all that stuff? Is there anything which says what Lord Brown says there is wrong and impossible?
Well, I would say this is a direct authority. We get analogical support from the Belmarsh case.
Yes.
Because on Belmarsh, it would be open to a court to say, well, if these people are released, we can't deport them. There's a temporary block. One has to remember that the block that the government accepted for the purpose of the domestic proceedings in the Belmarsh case, that the individuals couldn't be removed. They withdrew that concession in Strasbourg and argued that the fact that negotiations were pending meant that there wasn't a block, and that 5.1f was in play, and there wasn't any need to derogate, and Strasbourg rejected that. But let's say that the kind of temporary block that my Lord Brown had in mind is the kind of Belmarsh block. Well, no, you can't simply detain somebody for preventative reasons.
But can I just ask, is it the real world where there'll be a risk of reoffending but no risk of absconding?
Perhaps not.
Why not?
And the risk of reoffending could, of course, increase the risk of absconding.
Yes.
You accept that.
Oh, yes. Yes, because you'd want to evade...
Go to ground.
You'd want to go to ground. You'd want to evade... Yeah, they are linked. Yes. But it's important, we say, to get the starting point correct.
You mentioned two Grand Chamber cases, and I don't know quite whether they bear on this issue or not, and what those cases...
They're not on this issue. They're simply authority for the proposition that I think my Lord Roger wouldn't find that helpful.
Right.
The court may not find that helpful. They say that you've got to construe the exceptions to Article 5 narrowly.
I see.
And it's the Belmarsh case. I can give you the references if you'd like them. It's...
26252.
26252, thank you. Is that Belmarsh?
Thank you.
That's Belmarsh.
And Sardi is
25249.
25249.
Thank you.
And somewhere I've got the paragraph references as well.
Yeah.
You have them in the note, actually.
Yes, right. Thank you.
think.
I see that I agreed with Lord Brown on this point, and on this point, you said I got it right. So.
I think
You got it right on voluntary.
on voluntary repatriation,
voluntary.
on appeals and on real prospect of success.
So where is the pure light of doctrine to be found in That's what we were after all.
I thought it was
looked for.
paragraph 55, if I can accelerate your answer. I think that's where
Yes.
the bit that,
Thank you very much. Thank you.
that you want us to look at. That's the bit that's quoted in the Court of Appeals judgment.
It begins actually at 52, no, 51.
Yes, yes.
So, my Lord rejects the first objection about voluntary departure, the control point. That's not relevant. Of course, if the appellant were to leave voluntarily, he would cease to be detained. In my judgment, the mere fact that the detained person refuses the offer of repatriation cannot make reasonable appeal of detention which would otherwise be reasonable. Mr. Robber Wright, the refusal of an offer of voluntary repatriation would justify as reasonable any period of detention, no matter how long, provided that the Secretary of State was doing its best to effect the deportation. So that's the spectre of indefinite detention, which is rejected. So it's bad that the argument's bad on consequentialist grounds, so we endorse that, the court. So the second reason, the absconding point, I accept that if it is right to infer from the refusal of an offer of repatriation that a detained person is likely to abscond, then the refusal of repatriation is relevant to the reasonableness of duration. In that event, the refusal of voluntary repatriation is no more than evidence of a relevant circumstance, namely the likelihood that the detained person will abscond if released. 2 points to be made. First, the likelihood, if proved, shouldn't be overstated. It could be a trump card. So there's always time when enough is enough. It's just gone on too long. Secondly, for the Secretary of State to satisfy the court, not surprising, the appellant has refused repatriation. He's not yet exhausted the asylum process, which, if successful, would permit him to remain in the United Kingdom. In these circumstances, why should one infer an abscond risk? Most could be said is a real risk, can be said in most cases. 55, as regards the relevance of the asylum, I should say in this case, Justice Collins found a real risk of absconding, nothing more than that. The appellant's asylum claim appeal, and you already have seen that. My Lords, can I go back to my note? It's just I'm conscious of the time and Mr. Ravinder Singh and Mr. Fordham's position, indeed Mr. Belloff's. And the note, we say it's important to have regard to the context here, the middle of our first page. The United Kingdom will shortly be, from next month, the only state amongst the 27 EU member states to have temporally unlimited detention pending removal. The EU outer time limit of 18 months, and that is an outer time limit when the person is refusing to comply, not refusing to repatriate, there's a distinction, but refusing to comply with travel documentation. We say that is relevant because it goes to the machinery of deportation. When they're doing that, you extend the time limit for detention from 6 months to 18 months, and that was criticised by the UN working group at the reference I've given you, and also by the criticism is referenced by the EU agency. As far as Strasbourg is concerned, time limits are, of course, not mandated by Article 5, but they are recognised to be an important safeguard, absent which the need for judicial and procedural scrutiny is all the more important, which puts into focus, we say, the Secretary of State's submissions on the points that follow. You need all the more judicial and procedural safeguards where you don't have time limits. I was reminding Mr. Belloff that he had argued in Tanti Lam that prolonged indefinite detention is inhuman and degrading treatment. And we don't go so far as that, but it gives you an idea that there is a real problem here. This man has been in detention for 53 months. He's very, very mentally unwell. The Secretary of State says, she focuses at 2.7 on two main reasons for the length of this man's detention: voluntary repatriation and the pursuit of statutory appeals. She says about the Hardial-Singh principles that they're a long stop remedy, a long backstop, a remedy of last resort. There are other remedies. You can approach the Secretary of State, you can apply for bail. We say the Hardial-Singh principles amount to a constitutional protection, same points I was making yesterday, against executive detention. Bail is not an adequate remedy at all. It's not a review of legality, it's not 5.4 compliant, we've given you references there. It's speedy but not in depth. So much for the litigation behemoth that judicial review is, as the Secretary of State puts it. It's because it's a behemoth that we know that the executive were operating an illegal policy for over 2 years. That wouldn't have come to light in bail proceedings, because in bail proceedings, you get late summaries. The procedure rules, and I've given you reference to them, require the bail summary to be produced no later than 2 p.m, the day before the hearing. And the evidence is that very often you don't get any at all. So the immigration judge simply isn't helped. I've given you the references there. On the legality question, Sharp, in his work, in fact says that habeas corpus lies against a decision to admit someone to bail on the theoretical basis that their custody has transferred to the surety. And the reference to Sharp is 41, volume 41, tab 415.
My recollection, Mr. Hussain, is that in SK Zimbabwe, you argued that if Hardial-Singh meant there was no substantive justification for the detention, there was no power to grant bail.
Yes, I have reflected on that, and the Secretary has made a point. That was the orthodox view before Kadian was decided. Before Kadian was decided, it was thought Hardial-Singh set a limit to the existence of the power to detain. If you could not detain as a matter of condition precedent, then you couldn't grant bail. That's the way the statute works. You've got to be released. And we've seen something that the Secretary of State says in her case. They make the point at 12.15. I don't need you to turn it up. Given the time, it's probably easy if I just explain what the Secretary of State says. She says that Kadian indicates that Hardial-Singh goes to the exercise of the power. So the existence remains intact. Now, if the existence of the power remains intact, then you can grant bail conditions, or you can impose restrictions, technically. But that works in our favour because it's what you're told, my lords, my lady.
It does work in your favour.
It does.
It's a matter of practice.
Oh, right. Yes, but it also works in my favour at the level of principle, because what you're told is, look, Hardial-Singh hamstrings the Secretary of State. She can't do anything with an individual who she doesn't want to let out. But that's not right, because as the Secretary herself says, even when you release somebody on Hardial-Singh principles, because of the Kadian decision, the power to grant bail or power to impose restrictions remains intact. And that goes against her. Her idea that Hardial-Singh has got to be regarded as a remedy of last resort, a long backstop, because nothing can be done about somebody she doesn't want to release. The first point then that we make submissions on is the appeals point, and you've got the references there at page 2 of my note. Mr. Beloff seeks what we say is an a priori exclusionary rule. Time spent in detention falls out of account in assessing, I say HS2 or 3, that's short form for Hardial-Singh principles 2 and 3 as distilled by my Lord Sir John Dyson in the I case. It's the distillation that all the courts repeat now, so it seems. She says there are 2 exceptions. First of all, if the Secretary is delaying the appellate process herself, then that would count. And secondly, the causation point. That was the point, my Lord, if you remember, in the I case, where Lord Brown said that if the individual can't be removed anyway, then you can count time spent while they're appealing, because that's not the true or operative cause of the person being in detention. The first point we make is, what is the basis for this rule? Is it statutory? Is there anything remotely in the statute to suggest that it should be the case? The answer is no. On the contrary, the way the Immigration Act is set out, you are allowed to appeal both a decision to make a deportation order, so you are allowed to appeal when you're in 2-2 detention, and then you are also allowed to appeal now a refusal to revoke a deportation order. You can't appeal the making of the deportation order, but once the deportation order is made, you can ask the Secretary of State to revoke it, and you can appeal that. That was the point in the BA Nigeria case, the last case my Lord's heard. So there is an appeal contemplated in 2-3 as well. So the detention power is contemplating appeals. Well, it's certainly consistent with it. Contemplating is too high. But it's consistent with the right of appeal that the statute has given you. And where is there in the statute any hint of the kind of exclusionary rule which my learned friends contend for? There is nothing. So it's common law or nothing. Now, what it says against us is that if a person seeks to appeal, that's an exercise of a choice. He has brought detention upon himself. Now, that submission is premised on executive infallibility. The idea is, we get it right, you're wasting your time if you're appealing. You must be. You can point the example of a gay Iranian refugee who loses his claim for asylum, loses his appeals because everybody is applying a test which is not compatible with the Refugee Convention. They're saying, you go home and keep quiet, you're not going to suffer persecution. Everybody's wrong. The case reaches the House of Lords, and they say that's a wrong approach. That person had a very meritorious claim and appeal from the beginning. Everybody was wrong, and it is wrong, we say, in that circumstance, clearly wrong, that you write out of the equation the amount of time that that person has spent in detention. Pursuit of rights of appeal in respect of international protection claims are rights which are of fundamental importance, as my Lady Justice Hale, as she then was recognised in the Salim case. You've got the reference there. The detainee is not to be impaled on the horns of a dilemma. Do I appeal or do I remain in detention and have that period of detention not count at all to what's reasonable? The analogy is with the JCWI case. My Lord Brown may recall that. And the approach which we urge is a merit-sensitive approach. We're certainly not saying for a moment that if you're pursuing vexatious, abusive appeals, then you're entitled to say, well, look, I've been in detention for X number of months pursuing vexatious, abusive appeals, and you can, and you must release me because of that. There is a comparison to be drawn with the approach of the Privy Council in the agony of death row cases, where in Pratt and Morgan, for example, Lord Griffiths indicated precisely that distinction at 60 to 61. You don't count an abusive appeal, but you do count something which has potential merit.
So you accept that what the Court of Appeal said on this point was correct then?
Well, if you read it in that way,
because we are looking at what is reasonable in all the circumstances.
Yes, but if the appeal is an abusive appeal is not the same thing as an appeal which fails.
Yeah.
Because an appeal may fail at one point in the system and win later. So
if from unmeritorious you read, say, hopeless or frivolous or vexatious or something of that kind, then you have no quarrel with what the
I've got no quarrel there. There is a long stop. If somebody's doing that, you still can't remove them at any point. They exhaust their appeals and you still haven't been able to remove them. Then we don't say it falls completely out of the picture. The value that you ascribe to detention during that period doesn't go to nil, but it goes to, on a scale of 1 to 10, it might go to 0.5. But it's going to fall pretty much out of the picture.
So he does get a reward for unmeritorious appeal.
In the extreme case. In 99 cases, he doesn't. There is a long stop, we say. But in a sense, I don't want to be drawn into the margins. The point is that it's merit sensitive. It's merit sensitive. And that is recognised by the Secretary of State's policy itself. We've given you the reference to it. 221, it said that a person with an appeal may have good reason not to abscond. Well, the logic is that if you've got a good claim going through the appellate process, you're going to comply with conditions. Why should it be relevant in that context, but irrelevant as regards Hardy Singh? There is no statutory basis whatsoever to have this sort of exclusionary rule. There are anti-abuse mechanisms. Certification by the Secretary of State, and so forth. And the court is well able to have an eye on the merits. There's nothing wrong with that whatsoever. It's said against us that the problem with our approach, which is not that you suddenly count everything in as though nobody had appealed, but the problem with our approach is that the Secretary isn't in control and uncertainty is introduced into the process. Well, how is that different in the case with which the Secretary would have no trouble? So it's the case where there's no appeal. The person has cooperated with the embassy, but the embassy isn't doing anything. That's not in his control, her Secretary of State's control. And equally, it's completely uncertain as to whether or not the removal will be effective. Uncertainty is inherent in the lack of time limits. It's absolutely inherent in it. It's rather odd that the Secretary of State is praying that in age. Secretary of State draws an analogy with the Strasbourg cases, but it's clear.
Mr. Hussain, can I interrupt a moment? I am concerned about the time.
Yes.
You are currently grinding pretty small, and we've got a very full note from you. It is important that others have a fair...
Yes, my Lord, I'm very conscious of that. Well, can I just... I will certainly speed up, if I may. The analogy with the ECHR doesn't run because the Strasbourg court, even when Chahal was decided, counts time spent in detention pending appeal. It approached Rule 39 measures differently. But that was before Mamet Kulov overturned previous jurisprudence to say that compliance with Rule 39 was mandatory. So in the Chahal situation, the state was out of grace, not obligation, deferring removal. The individual had no right in play. That's not the approach that the court has taken in Riabakan, and you've got the references to it. There are conflicting approaches. We commend the approach of Mr. Justice Davis in the Abdi 2 case, and you've got the reference to that. He reviews the authorities. We commend the approach of Sir John Dyson in the Mamki case. You've got the reference to that. Indeed, of Lord Justice Laws in A.S. Sedan. We over the approaches in the last 3 cases in that bullet point. The absurd consequence of taking Mullen Friend's approach to its conclusion is that the appellant would be regarded as being detained for 8 months rather than 53. And on Mr. Justice Collins's logic, he wouldn't have been in detention at the time of his challenge, because there was a challenge pending. Abdi 2 has been followed in many, many cases. We submit, and the footnote is at page 55 at page 45 of our printed case. We therefore say, insofar as it endorsed an exclusionary rule, the Court of Appeal erred. And the application to our facts is set out at paragraph 136 of our case. I'll give you one more reference, if I may. The Secretary herself thinks that the appeal against the refusal to revoke the order, was not clearly unfounded. And the reference there is at 3B 2665. 3B 2665. This is not a hopeless appeal. That's not my submission. It's what the Secretary of State accepts. Non-cooperation, the second important point. You've seen, my Lord Sir John Dyson, in the I case. We say that's irrelevant to the detention purpose. I think all those bullet points I've covered.
Yes.
The EU return directive is interesting on that as well. We say, if you look at that, it's very clear that detention is for the purposes of removal. Removal is contrasted with the concept of return. Earlier on in the directive, return embraces voluntary return, but detention under Article 15 must be for the purposes of removal. We accept that a refusal of voluntary repatriation may evidence an absconding risk, but that must take into account all the circumstances. And where you've got an outstanding claim, it would be very difficult to do so, and we've given you the references there. And even then, it's not a trump card. Material non-cooperation is relevant to the detention purpose. We accept that because it's apt to frustrate the deportation machinery. However, Parliament has imposed a criminal sanction for that, and that must be taken into account. We don't say it displaces the relevance of this consideration, but we say it modifies that, and Mr. Justice Mitting gives us some support in that contention in the Wang case, and the relevant paragraphs are 25 to 27 and 35. Even then, indefinite prolongation is impermissible. Mikolenko, you've got the references. We cite, pursuant to our duty to the court, the case of Delinsky, which is an admissibility decision, which is against us on this point. We ask you to say that the principle favours the court decisions in Mikolenko and Massoud. That's the fourth section with Judge Bratzer in the presidential chair. And we've also given you some other references on that point. Again, it may evidence an absconding risk, but that's subject to the qualifications that we set out in the previous section. And for that reason, we say that the judge is below erred at the references there. Length of future detention, we say that what you've got to have is a realistic prospect of removal within a reasonable period. The vice of this is that otherwise you're going to have indefinite detention. I've given you some references there. In our case, the Court of Appeal erred in failing to consider this issue. It has been over a year since the hearing.
Mr. Hussain, don't bother just to read out what's there.
Yes.
And what's there is very thorough, it seems to me.
My Lord, yes. In that case, can I just explain the return directive point very quickly? What's said against us is that there are all these different kinds of detention, and so the directive doesn't set a norm which the Strasbourg court would apply, because it said that you can detain somebody when they claim asylum. Well, we say that really doesn't work, because the directive is directed to detention for the purposes of removal. The fact that you claim asylum during that, but the purpose is still your removal, the purpose of detention is still your removal, does not disapply the directive. It's the distinction broadly between first limb 51F, second limb 51F. The directive speaks to second limb 51F. And the Secretary herself concedes that if it applied, WL would be out. Is there anything else you want me to do?
On these points, you could also point out no one is effectively considered as detention
My lords, my lady, I'll let the note speak for itself, if I may. I'm sorry to have taken up so much time.
Yes, miss.
My lords, my lady, on behalf of justice, I'd like to begin by thanking the court for giving us permission both to file our printed case and also to make these brief oral submissions. I will make one brief submission on the first issue in the generic appeals, the causation issue, and then I will make a few submissions on the third of the issues that Mr. Hussain identified at the outset, namely the presumption issue, which is the focus of our printed case, which I will take as read and adopt without going through it. So may I turn first then to the causation issue. In our respectful submission, the appellant's case on this is one which has been founded on legal orthodoxy, and with respect, it's the Secretary of State's contention and indeed the Court of Appeal's reasoning which risks a departure from conventional principle. And I would like to refer, my lords and lady, to authorities and the underlying materials by reference only wherever possible. I hope I'll be forgiven for doing that in the interest of time. Of course, I'll go to them if I'm asked to. And I would respectfully remind the Court that many of the concepts which we today might describe as public law concepts were, as a matter of legal history, forged in the crucible of what would be called tort actions, particularly trespassory claims. And I just want to make reference to one classic authority from 1863, the case of Cooper and Wandsworth Board of Works. The reference is volume 39, tab 393. That was a case about a person's house being demolished. So they sue for trespass to their property. And the structure of the claim is the conventional one at common law. The plaintiff brings the claim and establishes the primary ingredients of the trespassory tort. And it falls then to the defendant to show lawful authority for the interference with the property rights, if it can do so. And note that as long ago as 1863, the court holds that because there has been a breach of the rules of natural justice in the exercise of the power, and the conceptual distinction between existence of power and exercise of power is actually referred to in the summary of the advocate's arguments when one goes back to look at the law report in more detail. But I hope it'll suffice if I simply remind this court of what Mr. Justice Biles famously said at page 420 of the report, when he said that a long line of cases dated back to Dr. Bentley's case establishes that, quote, although there are no positive words in a statute requiring that the party shall be heard, yet the justice of the common law will supply the omission of the legislature. So in other words, the rules of natural justice are to be read into a statute which is otherwise silent. And because the person there had his house demolished without notice and without an opportunity to be heard, so the court holds that the apparent lawful authority can't be established. There was certainly a statutory power to demolish the house, but it hadn't been exercised lawfully because it was done unfairly. Therefore, the apparent lawful authority falls away. The shield the defendant could otherwise establish to the action is no longer present, therefore the action for trespass succeeds. And in my respectful submission, what the appellants have submitted to this court in the present cases is analogically the same. They rely upon the tort of trespass to the person, of which an example is false imprisonment. And finally, under this submission, my lords and lady, I would only say this, that we would respectfully remind the court of the word of caution sounded by Lord Wilberforce in Davy and Spelthorne Borough Council. The reference is volume 7, tab 61, where, when the court has time to go back to it, you will recall that at page 276E, Lord Wilberforce said this, that in this country, the expressions private law and public law must be used with caution, for typically English law fastens not upon principles but upon remedies, and the principle remains, if I may say so, echoing Dicey, he said the principle remains intact that public authorities and public servants are, unless clearly exempted, answerable in the ordinary courts for wrongs done to individuals. In other words, in my submission, he has in mind there, amongst other things, tort claims. And Lords and my Lady, I would propose to move on, if I may, to the presumption issue. And here it may be helpful to remind oneself of the passages in the Court of Appeal's judgment which dealt with this at paragraphs 59 to 69. In our respectful submission, there are discernible in the Court of Appeal's reasoning there two essential bases for holding that there can, in principle, be a presumption in favour of detention. The second in order in their reasoning is the first one I'd like to deal with, because I can deal with it shortly, if I may. And it's the one which is based upon the language of the 1971 Act. And one sees, for example, the reasoning at paragraph 65, where there's express reference to Schedule 3 to the Act, and paragraph 2, which one has seen in some detail at this hearing now. And also the reasoning over the page at paragraph 68, when the court rejected the appellant's what they call powerful appeal to constitutional principles of liberty, because they said that has little bearing on a case where Parliament has specifically authorised detention. So the first strand of the reasoning is clearly founded on the text of the detention powers in the statute. Now, Mr. Hussain has addressed this at length yesterday. I don't want to repeat what he said. Suffice to say, I hope that in our respectful submission, the language of the statute simply does not bear the burden which was placed upon it by the Court of Appeal. There is no statutory presumption in favour of detention, and indeed the Secretary of State accepts at this hearing that the statute is neutral, in fact, so far as the Secretary of State is concerned. So when it comes to the Secretary of State's own exercise of administrative detention powers, the statute is silent. If that's right, then in our respectful submission, the powerful appeal to constitutional principles is directly in point. That's precisely when the principle of legality comes into play and is reinforced by the particular and jealous regard with which the common law protects personal liberty. Lords and my Lady, the other main strand in the Court of Appeal reasoning, the first in point in their paragraph numbering, is based upon Strasbourg case law, and one sees that particularly from paragraphs 61 and 62, where the court sees that they extract and quote the salient passages from well-known authority in Strasbourg, namely Chahar, paragraph 112 is there set out, and Sardi. And to paraphrase what those passages say, Strasbourg has held that Article 5.1f does not require a test of detention being considered reasonably necessary. But from that, at the beginning of paragraph 62, the Court of Appeal reasons that it follows that a national law that authorises detention with a view to deportation may be compatible with Article 5 even if it imposes a presumption of detention. Now, in my respectful submission, that is where there is a logical flaw in the reasoning. That is not something that follows. It is a non sequitur. And I would like to suggest to the court that one can test it first by reference to principle, and then I will briefly go to some of the Strasbourg authorities. Now, my lords and my lady, consider, for example, a policy which contains a substantive test for detention, which is similar to the one in the notorious Regulation 18B, the subject of Liversidge and Anderson. What the Court of Appeal, in my respectful submission, is doing in those paragraphs is confusing the substantive criteria for detention with a different question, which is the question of whether detention can be the default position, as it were, whether there can be a presumption in favour of detention. And in my respectful submission, the fallacy can be exposed in this way. To take my example of a policy which says that a person may be detained if there are reasonable grounds to suspect that he or she is a person of hostile origins or associations. So Regulation 18B, in effect, set out in a policy. That is not a test of necessity, I would submit. So that would be compatible with Saadi and Chahal. But suppose the policy then presumed that a person is such a person, perhaps because they are a foreign national, unless they show that the test is not satisfied. That would be to introduce a presumption into the equation. And in my respectful submission, the authorities the Court of Appeal relies upon, Chahal and Saadi, have nothing to say about that second question, whether a presumption will be permissible. Necessity is not needed. Presumption, we say, is incompatible with Article 5. As a matter of first principle, we say that must be right. Note, perhaps the obvious point, that Article 5 begins with the word everyone. Everyone has the right to liberty. That's the starting point under the Convention in every case. So it's always deprivation of liberty which has to be justified, not liberty itself. But in fact, the case law, such as it is in Strasbourg, and we accept that there is no direct authority on 5.1f cases on this point, but there is powerful authority on other limbs of Article 5, which we suggest sets out the relevant principle, and there's no reason in logic why the principle should not apply to 5.1f cases. That the principal authority, which has subsequently been approved in other cases, is the decision in Ilyakov and Bulgaria, which I will go to for a moment, if I may. That's in volume 24 of the authorities, tab 240. I should say that Ilyakov dates from 2001 and was considered by the House of Lords in the Harrow Crown Court case, to which I will make brief reference in a moment.
Could you give the reference?
Yes, certainly. Volume 24, tab 240. And just to anticipate what I'm going to say about Harrow Crown Court, my Lord Brown cited, and I understand with approval, certain of the passages that we're going to look at in a moment. My Lords and Lady, the consideration by the Court of the relevant legal issue begins at page 11 of the printout, under the heading The Law. And you see immediately, and I acknowledge, this is an Article 5.3 case. So it's about detention, custody on remand. And one accepts that, but it's to go to the principle about presumptions that this case is important. That begins with the Court's assessment at page 14 from paragraph 76. And in the interest of time, I won't go through this in detail, save to note that at paragraph 79, in the second line, you will see express reference to the word presumption. So there was a national measure under which there was a presumption that detention on remand was necessary in cases where the sentence faced went beyond a certain threshold of gravity. Very similar to the Harrow Crown Court issue, as we shall see. And then at the bottom of that page of paragraph 81, the characterization in law of the facts was determined by the prosecution authorities without judicial control. So in other words, in this regard, there's an analogy here because it's administrative decision-making only. And at 82, the point was made that in the national proceedings there were no exceptional circumstances warranting release identified, and therefore in paragraph 83, under Article 152 of the Code of Criminal Procedure, the Supreme Court's practice, the presumption was only rebuttable in very exceptional circumstances. And it was, note this is a distinct point about burden of proof. So there's a substantive presumption in the legal measure. There's also this procedural problem. It was, moreover, incumbent on the detained person to prove the existence of such exceptional circumstances, failing which he was bound to remain in detention on remand throughout the proceedings. That's the end of paragraph 83. And the court expressly identifies as defects both of those features in the national law and practice. In the middle of paragraph 84, in the second subparagraph, it disposes of the presumption. So the substantive legal criterion, being a presumption, is then said in that passage to be incompatible with the convention. But then at 85, the court turns to the distinct procedural question and says, moreover, the court considers that it was incumbent on the authorities to establish those relevant facts. Shifting the burden of proof is tantamount to overturning the rule of Article 5 of the Convention. No, it doesn't say 5.3. In my respectful submission, it's enunciating a general principle of Article 5, a provision which makes detention an exceptional departure from the right to liberty and only permissible in exhaustively enumerated, strictly defined cases. And perhaps the point can be reinforced even further when one looks at paragraph 86 at the top of the next page. The first 4 lines make it clear that the court was acknowledging that there might, in fact, in that case, have been facts that could have warranted the applicant's deprivation of liberty. But it was the fact that the national courts and indeed prosecution authorities were operating the legal presumption and also the shift of the burden of proof, which meant that that scenario did not prevent there being an incompatibility with Article 5. Now,
Is that at the end of paragraph 84?
yes.
What are they saying that you can have a presumption, but you have to, the facts which take it into operation have to be strictly proved, and otherwise you can't have a sort of presumption of the facts.
Well, Lord...
I mean, I'm just looking at it. I've seen it before.
I can see as a matter of language, it might appear to say that. In my respectful submission, as a matter of substance, it's clearly rejecting the idea of having a presumption because it's saying that you have to establish the facts in the individual case and not simply operate a presumption.
It rather reads, the first 2 lines read as if the law itself is providing for a presumption.
Yes.
I'm not quite sure what the case is all about and quite how it arises, but...
There was a national law, and forgive me, I went through the earlier part very quickly for reasons of time. But when you go back to see, you'll get a flavour of it, my lord, from paragraph 76 and onwards. But there was a law as well as practice in the case law in the national legal system.
So we're talking about a national law, are we?
Yes, exactly. Yeah. But of course here, although we're not dealing with the national law, we are dealing with policy, and I won't re-enter the debate about whether policy is law, but nevertheless, what the Secretary of State relies on is policy and says that a presumption is permissible under our legal system. Now, Iliakov has been subsequently approved and applied. It was approved by the Grand Chamber in a case I'll just give a reference to, if I may, called Ikov and Russia. That's volume 26, tab 243.
243.
Tab 243. And volume 26, tab 243.
Can it really be the... I mean, this bundle ends at 242. 243,
Yes,
you might have expected to be in the next bundle. Sorry,
Volume 26, tab 243.
I think it's probably 25.
I think it's tab 253.
Forgive me.
It does look like that, yes.
It is.
253 volume.
Forgive me. That's my error.
It's Bikov, yes?
Yeah. And that's quoted, if it helps, my lords, it's quoted in my learned friends, the appellant's printed case at paragraph 198. It's paragraph 64. And that was the Grand Chamber. It's 2009 case, so it's recent. And also quoted at paragraph 199 of the appellant's printed case is a recent decision of the first section. That's Bordikov. And Bordikov is, I hope I've got this number right, it's tab 258 in the same volume, 26.
It is. It is, you're right.
Thank you. And there is paragraph 88. But again, for ease, it's quoted in the appellant's printed case, paragraph 199. Now,
So, did you say 199?
paragraph 199 of my learned friend's printed case. So those are Strasbourg authorities, and they have their domestic analogue in the House of Lords decision in Harrow Crown Court, which we'll go to just for a moment. It's volume 16, tab 155. And the main opinion was given by my Lord Brown, which begins at page 257 of the report. And the court can see from paragraph 14 that this case concerned section 25 of the Criminal Justice and Public Order Act 1994 as amended, and specified a number of grave offences, essentially murder, rape and so on, where, as we shall see in a moment, in substance, there was to be a presumption against bail, and the individual would have to establish the grounds why bail should be granted, contrary to the normal principle in our law. And the end result was that, having regard to Strasbourg principles and case law, the House of Lords decided that section 25 needed to be read down to be compatible, and the gist of that one can see, again, forgive me for taking this very quickly, but page 262, paragraph 35.
Sorry, where was that?
Page 262, paragraph 35.
Thank you.
Where, in the opinion of my Lord Brown, he said that whether or not, strictly speaking, section 25 needs to be read down to achieve the agreed result. Just a little moment. I myself have a mild preference for Mr. Justice Hooper's approach. Like him, I read the section as placing a burden on the section 25 defendant. He has to rebut a presumption, and if he fails to do so, is to be denied bail. True it is, as Mr. Turner himself accepted, in the vast majority of cases, the court will reach a clear view, one way or the other, whether the conditions for withholding bail specified by Schedule 1 to the Act are satisfied. But just occasionally, the court will be left unsure as to whether the defendant should be released on bail, the only situation in which the burden of proof assumes any relevance, and in my judgment, bail would then have to be granted. That must be the default position. And I draw attention to that phrase because in our respectful submission, that's a helpful phrase because it focuses attention on the question of, well, it may not matter in the vast majority of cases, nevertheless it's right and important to get the principle right. So what is the starting point? What is the default position? If nothing else happens, if the individual concerned doesn't put forward anything, or the court is, or the other authority, in this case the Secretary of State detaining, is left unsure, what is to happen? What is the default position? And the House of Lords held the default position could not be one where there would be detention. Section 25, as my Lord there concludes, should in my judgment be read down to make that plain.
I mean, paragraph 28, I think, is really where
Yes.
you distills what, I mean, is intended to indicate
Exactly.
what
Indeed.
Illich Koff decided.
Indeed, and my Lord had just before that cited some of the passages I've just gone to in the Ilyukov case, and I'm grateful to be reminded of that, my Lord. Now, of course, we accept that that's in the context of 5.3 and remand on custody, but in my respectful submission, the authorities don't stop there. Time doesn't permit me, unless I'm asked to go to them in detail, but can I give references to two domestic authorities under the Human Rights Act? One arises from the familiar area of prisoner recall cases, and the other is a mental health case. The prisoner recall case I have in mind is Sim, and that is for reference in volume 41, tab 417. And I commend the court's attention to paragraphs 37 to 51.
Paragraphs.
Paragraphs 37 to 51. My Lord, if you go to it in due course, that you'll find is the judgment of Lord Justice Keane, with whom the other members of the Court of Appeal agreed. And that concerned a provision in a very complicated context of statutory provisions to do with extended sentences. And I have in mind the old meaning of extended sentences before the Criminal Justice Act 2003. And essentially what it boiled down to was that the parole board had to be satisfied that the prisoner was no longer dangerous. And that was read down by the Court of Appeal in order to render it compatible. And can I recommend particularly two paragraphs in the reasoning of the Court of Appeal, because again they shed light on what the correct principles are. First, at paragraph 42, Lord Justice Keane drew a helpful distinction, we suggest, between the concept of a burden of proof and the concept of a presumption, making it clear that burden of proof is not necessarily always helpful as a term of art, where the real question at issue is what is the substantive test. But they nevertheless thought that it was helpful in that context to conceive of there being a presumption. And the problem was, again, there was a presumption in favour of detention. Because if the parole board weren't satisfied of the negative, then detention continued. That was read down to make it clear that, in fact, they didn't have to be satisfied that way round. The presumption was made one of liberty. And the second passage is paragraph 43, where Lord Justice Keane expressly quotes with approval the analysis of Mr. Justice Elias at first instance. And again, I commend that because Mr. Justice Elias used the phrase default position, echoing something my Lord Brown said in the Harrow case. We suggest that that's a helpful way of looking at things because it focuses attention on the fact that it's not so much about who bears the burden, because that's a procedural question which may or may not help, but the default position as a matter of substance cannot be lawfully that detention will continue. You have to start with the default position being liberty unless then some substantive test is satisfied for restricting liberty. And the last authority, which I can refer to simply by reference, is the H case, which is a Mental Health Act case. It's referred to at paragraph 62 of the Court of Appeal's judgment in our case. Perhaps remarkably, amongst the over 400 authorities in this case, this has not found its way into the bundles. And I'm not intending to burden the court with any further additions to the bundles. My Lord the President and my Lord Sir John Dyson may recall this case was an early case under the Human Rights Act where a declaration of incompatibility was made. Subsequently, remedial order was made to amend the primary legislation to make it clear, as my Lords held in the Court of Appeal had to be made clear, that Strasbourg authority, particularly Winterwerp against the Netherlands, makes it clear that it's not lawful for detention of a mental patient to continue just because they can't demonstrate that they're no longer a danger to society, and it's the other way around.
If that case were heard today, one would simply read it down to make it mean the opposite of what the words actually do.
Yes. Come on. I suspect my Lord is right. In light of subsequent House of Lords authority, that's right. I cite that and the Sim case with some hesitation because I lost both cases to the Secretary of State. My Lords, my Lady, unless I can assist the court further, those are our orders.
I'd just like to go back to the starting point, and we can pick it up in paragraph 61 of the Court of Appeal's judgment. The starting point, it seems to me, is that 51F is different from other articles, and that the only restriction 51F places in relation to deportation is a temporal one. And as long as that you don't have to justify detaining the person, providing that you're detaining him with a view to deporting him. You can only do that providing you are taking reasonable measures to deport him and for a reasonable length of time. And it's the statement cited in Sadi from originally Jahar,
Yes.
the principle of proportionality applied to detention under 5.1f only to the extent that the detention should not continue for an unreasonable length of time. It's a startling proposition, having regard to most other.
And indeed, the UN
Right.
case law on the ICCPR, which we have set out because we hope it assists
And
to understand
it seems to me the court was
problem.
saying, as far as Strasbourg is concerned,
Yeah.
there's no reason. If one has almost an unqualified
Yes.
right to
Yes.
detain,
Look,
providing it's with a view to
Look,
deportation, you can't do anything
Yes.
that's contrary to Strasbourg law
Yes.
by watering that down a bit and saying, we'll detain provided A, B, and C, if those provisos aren't necessary anyway.
Well, in our respectful submission, there are two distinct answers to that. And of course, I see the force of the point. It's obvious from the case law. The first answer is that even if that is how Strasbourg is to be read, that the common law can give rights which are greater.
Yes.
Section 11 of the Human Rights Act makes it clear that the Human Rights Act adds to our rights in domestic law. It doesn't take anything away. And one can see a recent example in this court of that in play in the Ahmed case, the asset freezing order case that many members of the court will remember. And what the court there was faced with was a Strasbourg authority which was against the appellants, the case which is now to be considered in the Al Jeddah case, which has been heard in Strasbourg now. So the convention was a route which was barred, in effect, to the appellants. And nevertheless, the principle of legality operated with full force, so far as our own law was concerned. So I would not wish to detract from the power of common law presumptions and principles. I don't repeat what Mr. Hussein has said, but we say that in the common law, there is a strong principle in favour of liberty. And with respect, one of the reasons why justice has intervened in this case is that we were concerned to see the beginning of paragraph 63 in the Court of Appeal's reasoning, that no rule of our domestic law precludes...
So it's the Hardil Singh point coming back in the first sentence.
Exactly. So, my Lord, even if Strasbourg is against the submission, we would say that this is an appropriate case where the common law should be allowed to have its full and powerful effect. But secondly, I would with respect submit that the Strasbourg case law doesn't go quite as far as the Court of Appeal appears to have thought, because, and I don't repeat what I've said already, but the essence of my submissions has been this morning that there is a conceptual distinction, and an important distinction, between whatever substantive test for detention you have, and the Strasbourg case law establishes that it doesn't have to be a test of necessity. But whatever test you arrive at, and here there is a test, the Secretary of State, it could be a national law, but here it happens to be a policy. The policy doesn't say detain everyone. The policy presumes detention in certain cases, and it's that starting point which we say is unacceptable as a matter of principle. And that's where the Strasbourg case law, which I have gone to, which I acknowledge is in other Article 5 contexts, helps on arriving at the correct principle, we say, as a matter of analysis.
Thank you very much.
Lord and my lady, we echo Mr. Singh's gratitude, and we too commend to the court what we've put before you in writing. I'd like to deal with three topics. Firstly, I want to look at the generic parts of these appeals and suggest some basic duties which are on the Secretary of State. Secondly, I'd like to try to respond to some questions that you have asked in the last 2 days. And then thirdly, I want to deal with some points of principle in relation to Hardial Singh. The basic duties. We can get together 4 basic requirements of the law. They are these: that applicable detention criteria must be formulated by the Secretary of State. That's the first one. Those criteria must be consistent with the general law. That's the second duty.
Sorry.
They must be consistent with the general law. Thirdly, they must be published. And fourthly, they must be adhered to. You need all 4 of those duties to be complied with. They are not too much to ask. You cannot excuse non-compliance by using ideas of causation and asking a court to posit compliance. You can't escape the consequences of default by saying, well, if there'd been a judicial review, we could have made fresh action which would have rectified a default, at least prospectively.
Now, is that just a matter of assertion, or can you justify it in principle?
I can justify that in principle. Cooper and Wandsworth. So we wouldn't say, well, if you'd come to court before we pulled the house down, then I would have had the protections of a speedy public law challenge. I could have given you a hearing, and I could have retaken my decision afresh. And you can't escape the consequences by the fact that there may be a large number of people affected. If anything, that is a matter for increased gravity of judicial concern. If my lords and my lady have in mind, by way of reference point, the Secretary of State's own policy documents, I'll take just for illustration in Volume 2 of the Authorities, the manual from 2006. It's tab 17 in Volume 2. To anyone reading this document, it would have appeared that my 4 basic duties were recognised by the Secretary of State. Tab 17 in Volume 2 is April 2006. This is a published document that sets out detention criteria. It formulates the when, see paragraph 38.3, factors influencing a decision to detain. And it formulates the who, see paragraph 38.5, levels of authority for detention. So, for example, if you turn the page, it's page 8 at the bottom, in the sort of case with which these cases are concerned, the criteria required that the decision to detain must be made at senior caseworker level. And 38.5.3 have further similar criteria as to who needs to take the decision in particular categories of case. This appears to recognise the need to be consistent with the general law. Firstly, it says in terms on the first page the third paragraph from the bottom. This is, to be lawful, detention must be based on the statutory powers in accord with the limitations implied by domestic and Strasbourg case law.
First page.
First page, page 1, third paragraph from the bottom in the middle, my lord, to be lawful. Yeah. Detention must not only be based on one of the statutory powers and accord with the limitations implied by domestic and Strasbourg case law, it also recognises the link between this policy and law. To be lawful, detention must also accord with this stated policy. And the point is repeated over the page in the first complete paragraph, 38.1.1.
Does that mean, is that, when that, it says that there, does it mean that in order to be lawful, it has to comply with the substance of this, or is it because this policy has been announced, that is why it must accord with the policy?
It's both. It's both. It has to comply with the substance of the general law. And so, for example, Hardyall Singh is summarised on the second page, bottom half of the page. But it has to comply with these criteria in order to be lawful. That is what this says, and it's correct to say so. Can I give you an example? If you take page 8 and the very clear provisions about who has to authorise detention, starting with senior caseworker at the top of the page, in our kinds of case, and then other examples, unaccompanied young persons, children, and so on. It's very specific and it's very clear and it's mandatory. Suppose there were a secret policy or instruction which said, inconsistently with this, detention can be authorised by a junior caseworker, or detention is automatic. That would be unlawful. It would be false imprisonment, and it would be nothing to the point to say that if the right person had considered it, then on balance they would have authorised detention.
And that's because this has been published then?
It's because these are the stated criteria published as they are required to be. They are therefore part of the law.
And does that apply to this in all its fine detail? So if there is a departure from a relatively minor aspect of this detailed policy, that makes it unlawful?
No, I would accept...
Where do you draw the line?
Well, I would accept that there may be room for identifying some aspect of the policy as not going to the decision to detain. But the two examples I've given you deliberately most clearly do so. The criteria as to when and the criteria as to who.
I think in SKs in Zimbabwe we had discussion of mass outbreaks of flu, which were going to sort of mean that you didn't have the people of the required rank there and so on. I mean, does that mean that it becomes... I mean, we had discussions of
We did. We went through all of this, and you can posit it with the Roberts case.
Exactly.
You can't do a detention review because there's nobody available to do it. Well, the detention is unlawful. You have to meet the obligation.
So if you come to 38.8, which is the review system, you say, do you, that has to be adhered to the letter?
Yes, and
circumstances?
as you know, this takes us back to that case, but that is our submission, and that's because the function of the review is to authorise the continued detention. And it cuts both ways, because if you get the child case wrong at the beginning, but somebody who is the appropriate person conducts the review and authorises, well, then the Secretary of State can say, you've got continued authority from the second month onwards. But the opening paragraphs of this document are correct as to the legal import of this document.
But there's nothing, I mean, supposing they didn't have this, or they recategorised and said different people, there would be nothing to prevent. There's nothing to prevent them changing the levels of people who take it. It's only because they published it that that particular aspect of the policy is binding, isn't it?
You're right, but they're required to publish it, they're required to have criteria and publish them, but they can change them, providing they're consistent with the general law, and they are republished. I entirely accept that, my lord.
Well, if it's a question, a specific question of authority, there could be other arguments of lack of authority, whether or not there's been publication.
Certainly. And if there'd never been a policy, detention would be unlawful.
And it goes beyond mere policy, doesn't it?
Certainly.
Authorisation.
It does. The statute requires authorisation. Suppose you never had any decisions at all, simply a rubber stamp. You go straight to detention once you're released from prison, and nobody makes a decision at all. That would be ultra vires the statute. The statute requires a direction or an authorisation.
Well, that's Sadrati, isn't it? Which presumably you say is right.
I do.
And the Court of Appeal was wrong to overrule.
I do. Mr. Justice Moses was exactly right about the statute. Now, if I'm right in what I'm suggesting are basic duties, and this document meaning what it says, then it is no different. Just as you can have the right questions being asked by the wrong person, it's no different if you've got the wrong questions being asked by the right person. And that's this case. Why is this? Because legal standards matter. Because otherwise there is no real accountability, no reassurance for the court. The Secretary of State can simply ignore it or overreach the position, knowing that the court will simply reconstruct what would have happened if we'd complied, what would have happened if we'd had a policy, what would have happened if we'd published the policy that we had, or what would have happened if we had adhered to it.
What is the authority of saying you've got to publish a policy as to what level of person reviews cases and with what frequency?
I'm going to come because that's one of the questions I promise I'll deal with. Turning then to the questions, this is my second topic. My Lord Hope asked whether the rationale behind these legal duties to formulate and publish and then adhere to policy criteria is the safeguard against arbitrariness. We say, my Lord, that is right. It's paragraph 9 of our written case. And may I show you one authority, please, that you haven't looked at, and I hope it will take in its stride the question that my Lord Brown has just put to me. It's in volume 41, and it's at tab 414. And it's the case of Gillen. We refer to Gillen in the House of Lords in our paragraph 18 on page 9. But Gillen went to the Strasbourg Court. Can I pick up a number of points by using this recent authority? The first is, my lords, that if, and my lady, if you turn to page 1116 at the top, paragraph 21, you'll see that this is a convenient place to pick up something that Lord Bingham had said in the House of Lords. That's volume 16, tab 154. It's a quotation from his paragraph 34. The exercise of power by public officials as it affects members of the public must be governed by clear and publicly accessible rules of law. And that, as he explains, is part of a supremely important feature of the rule of law. Lady Hale asked, would the United Kingdom in Strasbourg rely on policy documents to meet this duty? You'll see in the next paragraph in the quote that Lord Bingham refers to the 2000 Act, powers duly authorised and confirmed, and then it defines and limits the powers with considerable precision. Code A public document, describes the procedure in detail. The position was stop and search under a statutory power, but a detailed code that told you who could exercise that power and on what basis. It dealt with the when and it dealt with the who. The code of practice is set out in section D at page 1126. Just picking up firstly Lord Hope's arbitrariness point, can I ask you to note please paragraphs 76 and 77, that's at the bottom of 1147 and at the top of page 1148. And one can conveniently see it in a single sentence, the penultimate sentence of paragraph 77 on page 1148. The law must indicate with sufficient clarity the scope of any such discretion conferred on the competent authorities and the manner of its exercise. Is the code of practice relied on? Absolutely. Paragraph 35 at 1126 tells us what it is. It's a code issued by the Secretary of State to guide police officers, and it's published. It's a public document. Paragraph 71 and 72 at page 1146 and the top of 1147, my lady will see the government doing precisely what she asked about. The government submits that the requirement of lawfulness is met by the combination of legislative provisions, information given to individuals, and the precise instructions in the code on how search powers are to be exercised. And at the top of 1147, it's a public document setting out detailed instructions. So that's the reliance on it. The court refers to it at 1148, paragraph 78, recognising its relevance. The Code of Practice, which is a public document, sets out details of the manner in which the constable, that's the who question, my lord, must carry out the search. Strasbourg goes on to disagree with the House of Lords as to whether in fact that was enough. And they hold that it wasn't, because although the code, see paragraph 83, dealt in detail with the mode of the stop and search, second sentence, the officer is obliged to comply, and then thirdly, third sentence, it deals essentially with the mode. That was not sufficient to provide the clarity that the legal standard requires as to how the power is to be exercised. And the ultimate conclusion is that at paragraph 87. Now that standard is the legal standard that requires the formulation of criteria and their publication and the adherence to them. And it is a heightened standard when you've got a deprivation of liberty. This was stop and search. My Lord Hope may remember that you had observed that it wasn't a deprivation of liberty. It was your paragraph 56, which Strasbourg quoted at their paragraph 22. You've got to look at the nature of the intrusion. That is right. If you've got a deprivation of liberty, it is the more important that you have very clear criteria as to the basis on which you are to be detained. The authorities for that are in our paragraph 17 I haven't got time, but the recent decision of the Grand Chamber in Medvedev, which is bundle 27, tab 263 in bundle 27, you only need paragraph 80 in the Grand Chamber's judgment. You'll see them answering at the point my Lord Hope had raised. Deprivation of liberty needs, most importantly, needs a high degree of certainty. Would a policy which simply said Hardy will sing and stop there be lawful? No, it wouldn't, we say. Hardy will sing is identifying the statutory purpose and the duty of reasonableness. The Secretary of State can do better, see these policies, and must do better in relation to the standards of the rule of law. Certainly, it's necessary for the policy criteria to reflect the general law, Hardy will sing, which is why you can't have automatic detention, and the presumption of liberty, which is why you can't have a presumption of detention. My Lord Roger asked in relation to the presumption of detention whether subparagraphs 1 and 2 of paragraph 2 of Schedule 3 would be run together if there were a presumption of liberty. Our answer to that is no, they wouldn't be run together. The reason why subparagraph 1 is separate is because it's dealing with a distinct situation where you need a duty to detain while you wait and see what the Secretary of State's decision is. The Secretary of State hasn't been involved yet, whereas under subparagraph 2, the Secretary of State inherently has been involved. It's like Mr. Singh's example of the parole board in SIM. If you had a statute that says you shall detain pending a direction from the parole board, that's a mandatory statutory duty to detain. But it certainly doesn't tell you that the parole board apply a presumption of detention. On the contrary, you wouldn't expect them to. And as we've seen, authority tells us that they don't. Put another way, you could add to the end of subparagraph 1 the words, in each case applying the presumption of liberty. You could add that to the statutory language, and there'd be no clash between the two things. Wait and see, detain while you wait and see, apply the presumption of liberty when the Secretary of State makes the direction. My Lord Roger also asked whether, in principle, policy criteria could be announced in Parliament. May I respond briefly to that? In principle, yes, policy criteria can, and you said it in the old-fashioned way they were. A good example is the parole cases. We've got Stafford in the bundles, volume 10, tab 99. My Lord Brown will remember the legal challenge in Findlay, which was to a policy which had been announced in Parliament. I think my Lord may have had that kind of situation in mind, but you'd have to be very clear that you're identifying your policy criteria, and you'd have to be very careful not to leave a published public document which purports to state criteria that you say you are going to follow that is inconsistent with what you're saying either privately or in the press or in Parliament. Stafford, my Lords, can I just correct, we have elevated Lord Justice Buxton to the House of Lords at our paragraph 13. But that doesn't detract from the fact that if you look at page 521 in Stafford, tab 99 in bundle 10, he says it all. He says, first of all, that there is a duty of adherence to a published policy, towards the top of the page citing the Findlay case. And then towards the bottom of the page, he explains the duty, this is Stafford, bundle 10, tab 99 at page 521. If you want to see the four duties combined together in a single page in domestic authority preceding the Human Rights Act, that's a good example. You also find the same point made by my Lord Phillips in Nadaraja at paragraph 54. You saw it yesterday, that law for these purposes includes policy, which it is the Secretary of State's duty to adhere to. Nadaraja, paragraph 54, bundle 14, tab 137, and finally, a very helpful distillation in a recent case in the High Court, Mr. Justice Blake, bundle 22, tab 222, so all the twos, 22, 222, paragraphs 76 through to 92.1. That's my second topic. May I turn to my final topic, which is Hardyall Singh, very briefly, and from the position of principle. As the court will appreciate, my clients have very grave concerns about the prevalence of long-term immigration detention, and I hope you've had an opportunity to look at the contextual material that we have sought to summarise for you. It is all too easy for the Secretary of State to use the vague hope of removal, the idea of public protection of someone who has served a sentence, and the idea of non-cooperation or their own conduct because they're not choosing to leave or because they're choosing to exercise their legal rights. Our points of principle, my lords and my lady, are these. Firstly, it is essential not to lose sight of the purpose of the detention. The purpose of the detention is to effect removal. That was said by Mr. Justice Wolfe. You'll find it at paragraph 45 of our written case in Hardyall Singh itself. And it's reflected in the Secretary of State's own policy documents. The first bullet point you will find, every time you open a policy document, will say detention most usually appropriate to effect removal. That's what Schedule 3 detention is doing. That's the first point. Secondly, the prospect of removal requires a disciplined and concrete focus. I'm not going to repeat what we've said in our case. We've set it all out in a couple of paragraphs, paragraphs 40 and 41 on pages 17 and 18. But it's a concrete question, including when are you envisaging, what timescale, what basis, and what likelihood. And again, that's reflected in the manual. Tab 17, Bundle 2, the very first factor to be taken into account, what is the likelihood of the person being removed, and if so, after what timescale? That's point 2. Point 3, abscond risk is plainly highly relevant because it directly relates to the purpose. The purpose is to effect removal, and if someone is at risk of absconding, that's going to frustrate the purpose of removal. But abscond risk is not a blank cheque. As my Lord Sir John Dyson explained in the I case, you saw it earlier on, it's paragraph 53 in tab 123 of bundle 12. That's the third point. The fourth point is that the risk of reoffending, and this is a matter of very grave concern, is not of itself a legitimate reason to detain. That would be preventive detention of non-nationals who have served their sentences, in respect of whom protective release arrangements can be made under the criminal law, and very clear statutory language would be required. And even if you had it, even if there were a provision that said non-nationals may be detained for up to 2 years where the Secretary of State wishes to remove them, that would lead you to very serious arguments in the context of what we know about discrimination and preventive detention of non-nationals. This statute goes nowhere near that. The purpose is to effect removal, and prevention of crime or protection of the public is not sufficient. Now again, by way of a reference point, if you look through the manuals and the guidance documents, you will find that protection of the public and the risk of offending does not appear
in the Secretary of State's own policy documents.
Mr. Fordham, could you just make it clear?
Yes.
As I understand it, these are arguments of our common law, not of Strasbourg.
Yes, correct. Yes. They're based on the statutory purpose. Yes. And I'm coming in just a moment to Sardi, and I've nearly finished. My Lord, absolutely, it's based on the statutory purpose. The Secretary of State's own manual, in setting out the criteria, repeatedly refers to abscond risk and risk of breaching conditions and so on and so forth. There's no mention of offending until you get to September 2008. That was the one that you were handed up, the loose guidance document that you had on the very first day. We can trace the idea back to my Lord Brown and my Lord Sir John Dyson in the I case. You've seen it, I won't go back to it. I simply make this submission that in fact my lords were dealing with a different point. What you were addressing was whether the risk of reoffending could be relevant to the reasonableness of the duration of a period of someone who was in immigration detention.
Well, I'm sorry, so you are accepting it's relevant to the length of detention, are you?
Yes. It's capable of being relevant. I agree with Mr. Hussain. It's capable of being relevant alongside abscond risk.
But not standing alone. It's only if there is also a risk of absconsion. Is that right?
That's right. That is right. And it's very important because the consequences, if that is wrong, are that the Secretary of State can simply say, here is someone, although they've served their sentence, who has committed crime and for preventive reasons, I'm going to keep them in detention. And you know the realities are 2-3 years of detention, often long exceeding the duration of the sentence of the court. How does that fit with Sardi?
Sorry, can I just... I'm trying to understand this. If you've got the risk of absconding, then that's all that's needed by the Secretary of State. I mean, how does the additional fact that if he absconds, that he would commit offences, how does that actually add anything?
Well, it may be that it doesn't, but the observation that was made, that I'm not disputing, is that if you've got a case of someone who is properly detained, and it is a case where there are serious reasons for the underlying deportation action, you can take that into account when deciding whether to give the Secretary of State a little longer to be able to detain them. That's the way it's put, and I don't disagree with it put in that way. But it's very corrosive if it's turned round into a principle to justify the detention itself, and that is what's happened in the subsequent policies and the subsequent documents. Now, Sardi, it's important for my lords and my lady to have in mind, please, if you will, that what Sardi does emphasise at paragraphs 74 and 76, it's tab 249 and it's bundle 25.
And the paragraph numbers are 25...
74 and 76. It's not simply about duration. The Strasbourg Court recognises the importance of the detention being directly linked to the purpose.
This wasn't deportation, was it?
No, it wasn't.
And 5F deals with purpose in the first part, but not in the deportation part.
51F deals to prevent an unauthorised entry.
Yes, that is purposeful.
Yes. With a view to removal.
With a view to...
It is for the purpose of removal. But my lord is right in pinning me down to the domestic arrangements. My submission on the authority of Mr. Justice Wolfe in Hardy Singh is that this statutory detention power is for the purpose of effecting removal.
Yes, I'm inclined to think we've gone far further in this country than Strasbourg would have required in this area.
Well, it won't be the first time, but that's the way I put it.
Yeah.
And all I say in relation to Strasbourg is that Strasbourg gives its blessing to the need for a purpose and a close connection between the detention and the purpose. If you look at the end of 74, that's referring to the length of detention. That's reasonably required for the purpose pursued.
It's just after, quote, to the purpose preventing unauthorised entry.
That's
Yes.
Strasbourg.
But it's simply, I suggest, not applicable to deportation.
Well, if the submission is this.
Doesn't Chahal deal with that?
Yes, Chahal is a national security case that deals with deportation and proceeds on the basis that the Secretary of State was entitled to detain someone who was a national security risk. The submission I'm making is in two stages. I hope it's clear. Stage one is that we have a detention power whose purpose is to effect removal. And stage two, far from disregarding the need to act in accordance with your purpose, it's part of the protection recognised in Strasbourg that you do precisely that. If you look at paragraph 76, in examining whether the detention was compatible with the criteria set out above, the court recalls the findings of the domestic courts. The national courts found that the purpose of the Oakington detention regime was to ensure the speedy resolution of claims. In order to achieve this objective, it was necessary to schedule up to 150 interviews a day. And then at the point that my Lord Phillips puts to me is repeated at the end of 77, closely connected to the purpose of preventing unauthorised entry. What I submit Strasbourg would say is that your detention has to match your purpose, and if your statutory provision is for the purpose of effecting removal, well then your detention has to be closely linked to that purpose. That's my submission. And
Sorry. I mean, Saudi is removing people on entry. I mean, is it Schedule 3 or is it Schedule?
It's Schedule 2, paragraph 18.
So it's sort of comparable provision.
It's a parallel. And my Lord,
but it's a parallel, but not in the context of removing people subject to court recommendation or on conducive grounds.
No, that's right.
I mean, that is a distinction that one ought to recognise.
Well, my Lord, it is a distinction. But my point is that the Oakington detention had a specific purpose, which was to effect an efficient examination. And if you look at Schedule 2, paragraph 18, it is a power to detain pending an examination. Now, one looks at the distinct situation of deportation detention and asks, well, what is the purpose in domestic law of that? The purpose there, I submit, is to effect removal. And therefore, the detention must be linked to that purpose. And Strasbourg, I submit, would recognise that. That's the submission.
If somebody is there's a risk that somebody will reoffend, is there not therefore a risk that he's going to be convicted and that he's going to have to serve another period of imprisonment if he's to be punished, and therefore that will make it harder to remove him?
I would accept that that could be the logic, that one could say that I need to detain in order to be able to remove, if I conclude, it's like absconding, that he is going to act in a way which will frustrate removal. I don't accept that it will always be the case. I don't accept that it will necessarily ever be the case, but I do submit that you would need to analyse it and address it in that way. And unless you've got a frustration of removal, one cannot detain.
I entirely follow your argument as a matter of our domestic law, but it's significant that Strasbourg's never said if you're detaining with a view to deportation, you can only do so providing that it's reasonably necessary to detain in order to effect the deportation. It said exactly the opposite. The only thing that matters is whether the deportation process is proceeding with reasonable speed. And providing that's going on, you don't need to show any more.
That I accept.
Isn't that right?
That I accept.
Yes.
And if the platform for my submission
Yes.
were Strasbourg, it wouldn't get very far. But that's not the platform
No.
for my submission. And one can posit a Sardi-type case. Suppose someone is on entry and you've efficiently examined their claim, but you think they might be going to offend, and you want to detain to protect the public. Now, it may be that Strasbourg would say, well, 51F gives the United Kingdom the power a broad power of detention, as long as someone hasn't got authority to enter. But that detention, we submit, would be unlawful. It wouldn't fit the statutory purpose. That's the submission. I hope my lords have it. Finally, in relation to non-repatriation and appeal, we agree with Mr. Hussain. It's quite wrong to characterise detention as self-induced because someone is choosing either not to return home or is choosing to appeal. Take Dr. Sardi himself. He is released from Oakington after 7 days, where he's been detained. Why is he released? Because he's got a right of appeal. He's not choosing to return home. He, in fact, vindicates his legal rights and wins his appeal because he is a refugee. And if the Secretary of State is right, that you put to the individual, you lay at the door of the individual their choice not to voluntarily go home, their choice to pursue an appeal, then it would be open to the Secretary of State to extend the Oakington system and keep everybody in detention while they appeal, for as long as that takes, and simply say, well, ignore that detention, because that detention is caused by the individual's own choice. The correct approach to this is that voluntariness, non-repatriation, can be relevant to abscond risk. My Lord Sir John Dyson agreeing with Lord Justice Mummery in the I case, and you've got the passages and saw those earlier today. Those are the points that I wanted to deal with. Unless you've got any further questions from me, with gratitude, those are our submissions.
Thank you. We're grateful to you. And we'll now adjourn until 2 o'clock.